Mobile devices, yeah.
It's only because my mobile device requires to be connected to the internet. Well, also, I mean, this is. I mean,
as long as it's on silent.
Oh yeah, no. That's what I've done already. Yeah, lovely.
Okay, right.
Let me try.
Livestream is on.
Contempt me to take the mask off now.
Sorry?
Contempt me to take the mask off.
Yeah.
Morning.
Good morning, how are you?
All right, thank you.
Letting you girls know, live streaming is off.
Off.
On.
On. Let's not have laptops. Just go to their room.
I've just done it. That's her one.
Oh, that's hers. His. You should be doing it for mine.
Doesn't look like it, does it?
I'm going to leave it there for him, and then he can do it. So.
Yes.
Have you put it in a supplementary one?
I'm assuming that would be the best place for it to go. I haven't done anything because I wasn't sure how the court wants to deal with it. We've got copies.
That's fine. Yeah.
I mean, it's quite a lengthy document, and it may just be that I note that it's. No, it's not all numbers, is it? Yeah. I mean, it would make sense for it to go at the back of the sub bundle, so 61 and onwards. I think that seems sensible.
No, that's fine. I agree.
I mean, I think it's right that it doesn't. That I think that the list. I'm not sure whether it should have gone in the core bundle. I'm not sure what the tax instruction says about pleadings or it's because defence. But anyway.
I'm not sure, but
anyway, but the easiest to put it in the supplementary bundle, I think. And,
I think so.
yeah, I mean.
Did you also see that the proof of delivery?
Yes. Is there any particular point that's been taken on that?
No.
Is
It's
it
just
for
to prove
completeness?
it's to prove the time and date.
Oh yeah.
I think it had appeared in the index.
Yeah, and then it's. I think there's. I think that actually what's in there is the one where it shows when the court.
Proof of postage.
Yeah, exactly. Or certainly when the court. No, it's not the proof of delivery to the court. It's the proof of sending to the court.
Yes?
I'm just going to shut the door, but when the judges come, we'll come in first anyway, so...
Yeah, as long as you just open the door.
No, but we'll come in and then they'll follow, so we'll let you know.
Okay. If I can ask you to have your mobile phone switched off because you wasn't in the room when I said that. Also, if you have any water bottles, etc., please keep them for yourself, and at the end of the day, take them with you or put them in the bin.
Thank you very much.
are we ready?
Yes, thank you.
Hopefully the judges will be here shortly. And this case is going to be live streamed, and live streaming is on.
Whether we've got this, was this what your solicitor sent, or was it just the signature?
It's just the signature page.
Okay, all right.
No, I have that. I think that one's in the bundle.
That one is in the bundle, isn't it? Although I think this is the NE18 version. Yeah.
Court rise.
No, not
Oh.
quite.
Sorry.
Someone said we'll
False
come in
alarm.
first.
Are the judges here?
Let's see. Yeah, well, two of them are. Said we'll come in first.
False alarm. That's why I think it's best if you knock, then we know that it's the judges. So if you do come in before and
Well, I said we're coming in first.
oh right,
Do you want me
gonna
to
sit
set up
with
the
it?
precedent?
Are you going to sit with it?
Are you ready?
Yes, we're ready.
I'm not, 'cause I can't get this thing in.
Court rise. Here in the matter of Diriye and Bojaj and another.
Yes, Mr. Peter.
My lord, my ladies, I appear for the appellant in this matter. My learned friend, Mr. Fardy, appears for the respondent.
Yes, you can take it that we've read the papers and we understand effectively the two issues, the issue about the signed for first class post and then the question of relief from sanctions.
Yes, my lord, do you have any preference as to which?
No, I'd take your own course, but I'm simply saying that we understand what the issues are, so I think you can take it obviously at your own pace, but I think reasonably pacey.
Yes, my lord, I will. If I could start with relief from sanction and the authorities bundle, I plan to take the court to Denton to highlight the specific points that I rely on, and then to take the court mainly to the judgment of the judge at first instance, but to some parts of His Honour Judge Lethem, who essentially approved the judge's, Deputy District Judge Goodman's reasoning.
Yes, in appeals of this sort, where there's second appeals of this kind, it's obviously the first judgment that's the one that matters.
Yes. And I start at page 69 in the authorities bundle.
Yeah.
Just to note that, of course, there were three cases, linked cases in Denton, two of which are the ones that I'm going to focus on, where there were effectively what were described as not particularly serious or significant decadent and utilised, and the facts of those are set out in 6 and 7. And what I'm going to do is take you, my lords and my ladies, to the guidance, and then say how that I say specifically applies in this particular case. So I move on to paragraph 24 on page 73.
Yeah.
The important point here is that what Denton says in terms of the 3-stage test is that the first stage is to identify and assess the seriousness and significance, and therefore they are conjunctive, not disjunctive. Both seriousness and significance have to be assessed.
Yeah.
In terms of seriousness, it's often said in the county court that any breach of a court order is serious, and of course it is. But because relief from sanction is concerned with the breach of a rule, practice, direction, or court order, it is not enough to say that because you're applying for relief from sanction, the breach is therefore serious. The seriousness of the very breach has to be assessed. In terms of the question about seriousness or significance, I say this is a case, as in paragraph 26 on page 74, where the question about significance really is a question of materiality. And that's because what paragraph 26 does is identify some breaches which are serious, but which could not, and therefore perhaps significant, but which could not imperil the future course of litigation, like not paying a court fee. When you're looking at the question of a breach which is about delay in complying with the court order, then the question of materiality, I say, is right. It ought to be right at the forefront of the court's mind. And therefore, the question is, what effect does the very breach itself have on the orderly conduct of the litigation? And I rely there on paragraph 27, where it says the assessment of the seriousness and significance of the breach should not, initially at least, involve a consideration of other unrelated failures that may have occurred in the past. That's, of course, not the case if there is a series of related failures that might culminate in an unless order, but this particular unless order that was breached was an order that is routinely made. It's not as a result of any particular failings. It's made for the orderly conduct of litigation in credit hire cases, because, of course, although the burden of proof is on the claimant, as it always is, the defendant, in order to mount a proper defence, will always need to see the claimant's financial documentation, and of course the claimant must also plead the facts relating to mitigation that they rely on. And so in credit hire cases, the sort of order that you found in this case, which, my lords, I'm assuming that you're familiar with, yes, is, I say, not an unless order in the sense of being an unless order resulting from anterior breaches by the claimant.
Well, I follow that as far as it goes, but if there'd been a full pleading of impecuniosity at the outset, the unless order wouldn't have been needed.
Well,
it shouldn't be for the court to constantly remind people of what they need to do in order to prove their cases. I understand that they are commonly made, but they're commonly made because claimants operate on the basis that it's enough simply to say I'm impecunious, and then come up with the detail later.
Yes, I'm constrained to accept that indeed that is correct. And what I would say about this is therefore that you have, I suppose I have to accept that there is therefore one related failure, because of course it's a requirement under CPR 16, if I've got it right, you plead all the facts in relation to impecuniosity. I say that what I will say about that is that the facts were then fully pleaded in the reply, which I'm very sorry, my lord, that wasn't included in the bundle, but I know that you have received it and seen it now.
Yeah.
But I accept. I have to accept that. I do say though that doesn't change the assessment of the significance of the breach, it does perhaps move it from the very bottom end of the seriousness. I say it was very close to the very bottom. It perhaps moves it up and but I say the more fact remains that the very breach itself, given when it was cured, did not have any effect on the orderly conduct of the litigation.
So is the essence this, that you're accepting it was serious, but not of the highest? Is that it?
I'm accepting, well, I say that seriousness and significance need to be...
I'm deliberately separating.
Yes.
You're accepting it was serious, are you?
Yes, I'm accepting that it was serious in that there was a failure to comply with a rule of practice direction which led to the order being made.
So there's two stages. There was a failure to comply with the practice direction.
Yes.
And then failure to comply with what really was the unless order.
Yes. Yes. However, going back to significance, only to say that this is a case, therefore, where my lady, I believe you said the not of the highest. I put it a bit more strongly than that. I'd say it was still very much not the most serious breach, and still.
Well, we end up chopping
yes.
too fine.
Well, yes.
I mean, serious and significant. It's serious. Is it significant?
Yes.
And you know, you can grade seriousness into all kinds of ways. It's. I don't think it's. These rules are supposed to be more straightforward than the rules they replaced.
I would say, therefore, that if the breach is not significant, then one should follow the guidance in Denton and say that not too much time should be spent on the second and third stages. And I say really that's the approach in this sort of case. And I say that whether the failure in terms of the reply what meant that there was deemed service of 2 days late, or deemed service, as I understand my learned friend will say, of 5 days late by rather convoluted.
Or actual service.
Or actual. Well, yes, actual service. Yes, well, exactly. So actual service, which on any view took place on 5 days late, 2 of those days being a weekend. I don't say in this context that 2 days or 5 days, as indeed I've submitted below, makes a great deal of difference. So, that being said, I say that in terms of proceeding to the extent that the court ought to have done to the third stage, in this sort of case, what ought to weigh most heavily is the effect of the very breach itself. And in this and in this regard, perhaps I might slightly modify my position in respect to the unless order in relation to paragraph 44 of Denton, which I'd ask my lords and my ladies to turn up. I do say that the court can take into account whether an unless order was truly required. And indeed, what is, of course, what in the final paragraph there is, that unless orders should be reserved for situations where they are truly required. The situation you have there was you had a pleading which didn't do what it ought to have done. However, at that time, there was still more than 7 months to go to trial, which was on the 1st of November. It is, I say, it's difficult to see that that's an order which can be said to be proportionate or required.
Sorry, so this is a criticism of the unless order?
It's a criticism of the unless order, yes. But
Gosh, that is going it a bit. So there was an unless order,
yes,
2.5 years ago, which you now say shouldn't have been made.
Well, I say that in response to the point which has been raised with respect by you, my lords, which is not a point that the defendant or respondent took, And I suppose if it and I have to accept that I confess I hadn't seen it like that up until it was put to me. But I accept that is the case. But what I say about that is that an unless order. It may be said it's going it a bit strong. Equally, one could say that an unless order in those circumstances is going it a bit strong. One that will deprive the claimant of a large proportion of the financial benefit of his case.
But isn't the point of the unless order so that the thing doesn't actually get to trial, because the defendants need to know what broadly is the quantum that they're likely to have to pay out, so they can make an offer or pay some money into court, and it's better that they don't have to wait until just before the trial to do that, isn't it?
Absolutely, my lady, and therefore, I mean, I suppose the point here is that when you're looking at the third stage of Denton, I say what should weigh heavily with any judge, and what it would be an error not to weigh heavily, is the question of what would the effect be if the defendant was provided with that full information 5 days after the date for compliance.
So you say that's under the third stage?
Well, to the extent that you have to go into the third stage, all the circumstances of the case, I say that it starts off, if the breach is not significant, with effectively I suppose the scales pointing towards relief. But of course, there can be other factors which are always.
But you say that it's not significant because you say it had no effect.
Yes.
So, but now under the third stage, you're back to effect.
Well,
I mean, effect either goes to significance or it's part of the overall circumstances. Isn't that right?
Well, effect goes to significance.
Which do you say? Effect?
I say it goes to significance.
Right. Okay. Fine.
And I suppose what I'm saying, perhaps if I might reformulate it, is that that's the reason why the scales are tipped in favour of granting relief at the third stage. And I say it takes something strong on the other side of that. I say to tip the scales back, and I say that this was a case where you didn't have that, and that's perhaps where I'm going to move on in terms of the law to the service issue before going to the judge's judgment. My lords, I say this is a simple point. I really do. Its good service would have been affected by first-class delivery. The question, therefore, by some other method which provides for service on the next working day.
Yeah.
And effectively, I say if it isn't fish, it's foul, so to speak. As in, I say first-class sign for delivery is first-class delivery, but if it isn't, then it is a delivery service which provides for service on the next working day.
Yeah. Now, we've been assisted on this point by the document that Lord Justice Holroyd asked for, the Royal Mail United Kingdom Post Scheme. Is it right that neither the DJ nor Judge had this document in front of them?
That's correct, yes.
Because I find that a bit surprising, I have to say, because on one view, it makes a number of the things fairly clear. For example, at 9.4, we aim to deliver a Royal Mail signed for first-class item the next working day after it had been posted. And you rely on that, as I understand it, to say, therefore, it's either first-class post under 626, it's either first-class post or some other service delivering the following day.
It's page 21.
Oh yes, no, I have that. It was something else I was looking for. I was going to take the court to what was before the court, which was at page 54 of the supplementary bundle.
54.
Yes.
That's the letter enclosing it with the post office certificate of posting.
Yes. And essentially that was what was relied on in certainly before his on Judge Lethem, because of course it identifies that it's signed for first class and then delivery aim at the bottom next working day.
Yeah.
And therefore, I mean, whereas I accept that well, I say that the Royal Mail document puts the point to bed, and I'm not going to say anything further about it. I absolutely, I say 9.4 is couldn't be more clear. But I say that can equally be divined from the document at page 54. It is first class post. It's a particular variant of first class post. It's not second class post, for example.
Well, one has to be a little careful in hanging these things on the wording, the precise wording, because the same rule has to apply to the equivalent wording of other providers, Hermes and Whistle, and they may phrase it slightly differently, but this, you would say, does make it clear that, as the chit stapled to that letter makes clear, that the aim is to deliver it the next day.
Yes, I suppose I say that it is. I don't say it'd be wrong to take judicial notice of the fact that first class post does not guarantee delivery on the next working day, and therefore, when saying first class post or another service which provides for, then that looks more as if you're not suggesting, or it's the frame of the rule, we're not suggesting first class post or another postal service which guarantees delivery, but rather one which in the ordinary course of events will deliver on the next working day. And that's of course why you have the deemed service rule in order
Yes, I mean the Royal Mail does offer another service which is guaranteed, for which you pay more than you pay for the signed for, and the signed more than you pay just for a first class stamp. So
yes, I have to say the court might consider it seems a little odd that litigants may be penalised by doing something which might ordinarily seem to be sensible.
Well, that's your point, isn't it?
Yes.
You mean penalised because they're using a system which is arguably more certain than first class post because you're getting a signature, and you say if the DJ or the CJ were right, then actually it's a lesser service.
Yes.
Yeah,
yes, exactly. Well, if the DJ or the CJ are right, my learned friend realistically accepts that it really would be putting it very high to say that the service was invalid. But that's effectively what the DJ was saying, and indeed, as I understand, it's what Judge Lethem was saying, because of course, if actual service takes place, as in a Bila Badarani type service, bringing it to the attention of the other party in litigation, well, the ordinary application to make is effectively for that to be deemed service, but you have to make the application. So unless and until you do that, then your service is valid, and in a technical sense, maybe there has not been proper service.
And as a short point, that the person who takes this sign for first class mode of sending a document is actually taking an extra step. So it doesn't seem to make a great deal of sense that the person should be penalised in any way by taking that extra step.
Well, no, and as I said, I didn't want to dwell on this too long, but it should be noted that the default mode of service, or the default is service on solicitors. If solicitors are nominated in the European Economic Area, then that is who another party has to serve upon. And I say that the idea, therefore, that there should be a problem with first class sign for because there might not be someone to sign for it, which is what my learned friend says, I say flies in the face of reality. Because, of course, in the majority of cases, that's going to be serviced by post on a solicitor's office where one would ordinarily expect there to be someone to sign for it. What happened in this case, it would appear, or what would ordinarily happen, is if the post takes a bit longer, and again, that is the purpose of the deeming service rule, to protect litigants from the vagaries of the postal system. So I say that's why, in reliance on Anderson and the other authorities in the authorities bundle, which I don't propose to take the court to, I say that the deemed service would be the correct approach here. I recognise it's a point the court has to determine. I recognise it's the reason why we're here. But I do say that in the overall context of the appeal against the order, it is not of the greatest significance in terms of whether the service was 2 days or 5 days.
Yeah, we understand that.
Yes. I'd now move on to the judge's judgment, Deputy District Judge Goodman. That's of course at page 91 of the bundle. Now, of course, I recognise the hurdle that has to be overcome when appealing a decision on an interlocutory decision, a relief from sanctions decision. Effectively, is, of course, it's not enough for the court to disagree with the decision. It has to be outside the reasonable ambit of decisions. And but it's, I say, it's not the end of the story. What I rely on heavily here are what I say are the irrelevant considerations taken into account by the judge, and that's what I say takes it outside the reasonable ambit. And so the judge starts off by reciting the breach, paragraph 1, and paragraph 2 perhaps it could say sets out the sort of the boundaries of the service issue. Say the claimant's counsel says it was deemed served on the 6th of April, and defendants say they received it on the 9th of April. The order being for it to be served by the 4th of April. Now, there are several breaches here, and this is where I'd say the judge starts to fall into error, because the first breach identified, whereas it is a consideration of relief from sanction, is not a consideration of the very breach. It is the explanation. What the judge says at paragraph 3. And I accept that, although I wouldn't quite characterise the explanation as the way the judge does, well, it's still, there is the explanation that the claimant said and has submitted all along is that the solicitors mistook the rules of service of the claim form for the rules of service of another document.
Do we have a copy of this statement?
It's in the it's in the application notice itself, where it's signed by and verified by a statement.
Sorry, my question is, do we have a copy of it? Is it in the bundle?
The application notice, yes.
I'm just asking about the statement. Because I think when the application was made for relief from sanctions, it wasn't supported by a statement.
Yeah, the statement is set out in the body of the application notice itself.
Right, so that's page...
wondering if we're in a little difficulty.
My lord, my ladies, if I may, it's not in any of the bundles.
Right.
That is a difficulty, and I'm very sorry.
Well, that's all right. Those can be, if it's in the application notice, then immediately after the hearing is probably the best way. That needs to be emailed to our clerks rather than handed up, because in the current conditions, I think we're not accepting documents handed up. But that will need to be emailed to us immediately after the end of the hearing. So there isn't a statement. It's it's something in the notice itself.
I say it is. However, it's in the body of the notice where at the end it's signed and verified. So it is. Okay. The judge is probably right to call it a statement because it's signed and verified by Robin Thackerdin, a solicitor at Lincoln Harford. Okay, and the judge is unimpressed with the claimant not attending the office and the alleged misunderstanding of the rules. Yes, and I say that's fair enough. The judge is entitled to be unimpressed by that, but only in the context of the explanation, not, I say, in the context of the first stage of the seriousness or significance. No, we're on to stage 2. Yes, that's relevant to stage 2. It doesn't matter about stage 1. It's stage 2. The judge said, and you said,
you say that you can't argue with that the judge was entitled to find there wasn't a proper explanation.
Yes, absolutely. But I do say it's important. Perhaps it's not important to very strictly, I suppose, follow. I suppose in a box ticking way, the Denton guidance. But if the judge identifies that they're looking at the breach, I say what they shouldn't be doing is then going on to the consideration about the explanation, because the first stage is the
Well, it's not a chancery document, it's a
No.
judgment given over the phone in slightly difficult circumstances. So if she dealt with the lack of a decent explanation first, well,
Yes.
there it is. Okay.
There it is.
So then paragraph 5 is the first class post point.
Yes, and for the reasons I've submitted, I say that the judge was wrong to find that there was not deemed service on the 6th,
Yeah.
and so therefore that is not a consideration that the judge should have taken into account whatsoever. Paragraph 6 is again going back to the explanation.
Yeah.
Yep. And then paragraph 7 moves on to the third stage.
Yeah.
And there, the first identifies that there's no prejudice, but then says that there's a further problem because the application for relief from sanction was not actually made till the 31st of May and received in this course of the 5th of June. And that is, of course, a consideration which ought to have been taken into consideration. Forgive me for that repetition, but what I say about that, and I say it's very significant, is that the only way in which that could be taken into consideration and should have been taken into consideration is to look at the effect of the very breach, because the key point
No,
here...
Mr. Peter, that's wrong as a matter of principle. The authorities make it clear that the delay in making an application for relief from sanctions is itself a relevant consideration under stage 3, irrespective of effect.
But what I say, what has to be, I suppose, what that has to be tempered with then, I'll say, what it has to be tempered with is the question of whether the defendant ought to have, in this case, consented to the relief from sanction being granted, i.e., as was asked for shortly after the breach took place and it was identified. The claimant solicitors asked the defendant solicitors to agree to a consent order granting relief from sanction, and I probably need to go back to Denton here, so do forgive me. My lord.
How can you say they should have agreed to it when in fact the judge refused relief from sanction? I can see that an argument that they should have agreed to it is relevant, maybe as to costs, or if relief is granted, and then you would say, well, they should have agreed to that. But if it's not granted, I'm not sure how that can be a good point.
Well, I suppose the point here is that I suppose we're looking at it today, and if this court were to reverse that decision, then it would be difficult for the defendant to rely on that point, because the position would be that the order has been set aside. But I suppose the overarching point here is that what the judge goes on to do is to say that that significant delay, and certainly this is something he's on Judge Lethem placed heavy reliance on, has disrupted the orderly course of the litigation. And the point here is that that has to be taken in the context of whether the defendant ought to have consented to relief, which I say Denton says that you ought to do when a breach is not significant. So that's my point there. So I mean, it becomes quite circular because you return again to significance, but perhaps that demonstrates the importance and the primacy of the assessment of significance, and why in Denton it said you shouldn't take too long on the third stage, because you start to get into these questions which don't have too much bearing on a breach that was not significant or should not have been significant but for the defendant's intransigence.
So what you're saying is the disruption to the proceedings that has resulted is as much as a result of them refusing to consent to relief as it is to the initial breach.
Yes, absolutely. And I suppose look, taking a step back from that. Denton was a judgment which explicitly stated that the guidance was intended to discourage satellite litigation, and of course it's a case like this, which I say it's directly relevant to, because that's exactly what happened. I say this is relief from sanctions application, not that needed to be determined by the court, but that ought to have been determined by consent and therefore didn't need to trouble the court. And that, if my ladies are with me on that, that's something which must be laid, I say, fairly and squarely at the defendant's door, because that happens before any delay in making the application.
What was the paragraph in Denton you want to? We don't need to look at it, but just give it for my note.
Yes. It's paragraph 43.
Thank you. Of course, Denton is designed to try and avoid, where possible, satellite litigation. It's also designed to try and ensure that people comply with the rules in the first place.
Yes, but perhaps if I also refer to paragraph 42, which states it should very much be the exceptional case where a contested from relief from sanctions application is necessary, and I say this is not an exceptional case in those circumstances. One can put forward legions of examples of witness statements served at the last minute, of long chains of failure, of breaches which imperil a fixed hearing date. Those are all more exceptional than this.
So just looking at the wording of paragraph 43, you say it was unreasonable
Yes.
of the defendants to oppose this application.
Yes.
Yes?
Yes, absolutely. The point is there, of course, is that even if it was reasonable, and I say it was unreasonable, but the question then of I suppose the whether there might be some other way of dealing with the application for relief from sanction rather than activating a strikeout would mean that even if it was reasonable to
It wasn't a strikeout.
well, it was a strikeout of part of the claim.
Well, that's the different point. It was not a strikeout. It was just saying you can't rely on impecuniosity.
I'll rephrase it. The effect of which would be that the majority of the claimants claimed for financial damages would fail. It would have
Thereby demonstrating the importance, possibly even the significance of this part of the claim, and the need, therefore, to get the impecuniosity case in order at an early stage.
Of course, and it was.
Well,
That's my point.
Well, we'll come back to that when we get to the relevant part of the district judge's judgment.
Well, yes, exactly. And so going back to the district judge's judgment on page 92, and then in fact moving over to page 93, of course I accept that it wasn't a prompt application, and again this is a point against the claimant.
So which paragraph?
Paragraph 7. But we've been talking about promptness, and I should just say for completeness, I accept it wasn't a prompt application.
Yeah.
I do say that even at the point of the hearing of this application, the 21st of August 2018, the fixed hearing date was not imperilled by a grant of relief from sanction. The defendant will say that there was prejudice, and I'll come on to that in consideration of the third stage. But
Prejudice. The new rules are designed to avoid arguments about prejudice. That's going back to the RSC. Prejudice is not the most relevant concept anymore.
Yes.
So we can look at what the points are, but gone are the days where the defaulter can say the court should let me off because there's no prejudice.
I suppose yes, but the point I was making there was about the imperilment of the fixed hearing date. I was saying the defendant will say there's other prejudice in the conduct, but it is a consideration in a relief from sanctions application whether the grant of relief will necessitate or make more likely the adjournment of a fixed hearing date.
Well, that's part of the consideration.
Yes.
And when was the hearing date fixed?
1st of November 2018. And the application came on to be heard on the 21st of August 2018.
Yeah.
But presumably it didn't happen in November 2018.
Because there was an appeal. Permission was granted to appeal, and then although there was talk when that appeal was dismissed of getting the case back on, the parties agreed that it would be more appropriate to wait and see if the Court of Appeal gave permission, and then. Depending on the outcome today, of course, either it will still go back, or of course, in fact, it will go back no matter what. It's just in what sense.
Yeah. But the application, the submission that the trial date could have been kept is simply because the hearing was in August and the trial date was fixed for the 1st of November.
Yes.
In fact, on the timetable that the district judge set out, there were a number of steps to be taken before the trial date. Here we've got a delay of 4 months from when the order should have been complied with through to the hearing, which has been preparation time and the various things that are timetable to be done, which has been lost.
As I'm sure my learned friend will confirm, all the further procedural steps were complied with. Up to the point where relief from sanctions there was relief from sanctions application was heard. It was only when it became apparent that there was going to be an appeal from that, and that of course that would therefore be a relevant consideration for the trial of the action. That's when the action stopped.
Yeah. Okay. Well, that's back to prejudice and so on. All right. So
yes.
What do we look at next?
Yes. Then we so we move on to paragraph 9. And where the judge says there are a number of matters which fall foul of the Denton guidelines, and then the judge returns to the 3-stage test at paragraph 10.
Yeah.
I say that the judge does fall into error by saying that the failure in itself to comply with a court order is taken as very serious by a court and has to be taken seriously. In that, of course, accepting the primacy that's given in the new relief, or what was once the new relief from sanctions regime, to compliance with court orders, in that sense, is not enough to say that just because it's it's failure to comply, it's very serious. As it suggests the judge has directed her mind too much to that aspect. It said at paragraph 11 that I conceded that that's because I say that any court order breach is serious, and I've addressed that.
Well, you accept it's serious.
Yes. Yeah.
Your point is about significance.
Well, exactly, and I suppose the judge says here, he says it's a minor breach, and I disagree. In my judgment, there's more than one breach, and they are not minor. And specifically, the judge is considering the first stage here, and this is where I say that again, this is an irrelevant consideration, because what she should have done is consider the very breach itself. And as I made the point when making my submissions about Denton, but the problem is that had the judge actually followed the guidance in Denton, she would have concluded, I say, and she was bound to conclude that it was not a significant breach, because the effect of the very breach was that the defendant had this information 5 days later at the most, and that was the effect, the limited the effect of the orderly conduct of litigation.
Yeah.
These paragraph 12, I'm not going to deal with them. Again, I accept there's no good explanation. But then the third stage is to evaluate all the circumstances, and there's here an issue about the reliance that the judge placed on whether the claimant had complied with other orders.
Well, 13 to 16 can be taken, I think, together.
Yes.
And it's an analysis of where the court was in relation to the impecuniosity assertion.
Yes, I mean, but the question, I suppose, is as His Honour Judge Lethem recognised, I suppose, the weight that should be ascribed to that particular.
That's a matter for the judge. The question is whether there's something here. She is looking at impecuniosity and the pleading of it, and the material to support it. That's part of the circumstances of the case.
Yes. And
she says the claimant hasn't given the information that he was required to do.
And this, well, he was required to do if it was in his possession or control, and that was a submission made to her. And whereas it may
let's cut to the chase, Mr. Peter, because I think we'll save time. The reply isn't in the bundle, but I've got it. On the impecuniosity, the claimant needed the replacement vehicle because he was a minicab driver.
Yes.
Yeah? Yes. The only relevant bit of the reply that goes to that is the sentence, as he earned cash as a minicab driver, he expended the same on bills and daily living allowances, which is no more information about the assertion of impecuniosity than the court had before that was said. So hence the district judge says, well, where are the accounts? Where's the material that shows what he was earning, what he was spending?
And the claimant says, I do not have it.
But if he didn't have accounts, he's working off book.
Yes, that's correct.
Right. So there's potential criminal offences. I mean, the district judge sets out the sorts of questions that any judge is likely to ask about somebody claiming that they work as a minicab driver, hence they need a new vehicle, but they have no financial records relating to that employment or self-employment at all.
I say it would be dangerous to draw any conclusions without having heard from the claimant on the matter.
No, you don't get to a trial when you are the subject of an order to provide the information. That's what the order was. So we're looking at 13 to 16.
Yes.
I would suggest to you, Mr. Peter, that what 13 to 16 does is the reaction of any judge who has a claimant who has asserted impecuniosity for a particular purpose and has said the sentence in his reply, and that's all, that I've just read to you.
The breach, though, that was being considered by the judge was a breach of a disclosure order, a separate breach of the disclosure order, which...
No, that isn't right. Leave the disclosure order aside. Just leave the question of the reply.
Yes.
The claimant was required to plead the details of why he said he was impecunious. So what you do in those circumstances is you plead your income, you plead your expenditure, and you demonstrate how and why on those facts you are impecunious. And that hasn't happened.
My Lord, all I can say, and I'm bound to say it as an advocate who deals with these cases in the county court, is that I have not ever seen such a reply which sets it out like that.
Well, then we may be able to give some guidance. You can't just say he can come along to court and say that. How could anybody cross-examine him?
Because he's provided his all of his bank account, his financial
But that doesn't contain any information about his minicab employment, which is the most important element of the case, because he wouldn't have needed urgently a replacement vehicle had he not been a minicab driver.
Absolutely, and how it might go at trial is that he would have what is included in his witness statement as well as in his reply. And I do say
don't have a witness statement.
What I'm saying here is that the reply pleads effectively that they're impecunious. That I say that the pleading here is that he expends the money that he gets on his daily living. That is said. I say that's not a defective reply, but he cannot produce at trial evidence of his accounts.
Well, I read it slightly differently. I thought that he's a minicab driver. He has to have a car for 5 to 6 days. I thought the dispute was whether he should have hired a car himself on ordinary car hire terms, which would have led to X damages, or whether he had to do what he did, which was to get a credit hire car, which I understand means that somebody else, a credit hire organisation, rents the car, provides it to him without charge to him, and then the credit hire organisation gets the money back from the defendant directly. But they charge a lot more than the claimant would have had to pay if he'd just gone to Hertz or whatever and hired a car himself. And isn't the dispute over the difference in the higher rate?
Absolutely. And the question for the court is whether the claimant can establish, because it's his burden to prove, that his income was not sufficient to hire on an ongoing basis at the market rate.
For him just to go and hire a car himself and pay for it and then claim it back, but he had to go to this credit hire organisation for them to hire the car, charge more, because he couldn't have, his impecuniosity was such that he couldn't himself afford to go and hire a car to run his minicab business because the car was written off in the accident.
So a claimant who goes to court, claimant can go to court and say, yes, I couldn't afford it, I don't have any accounts, and I'm paid in cash, and I don't have any records, and it may very well go badly for him there. But
you shouldn't go to all the time and trouble of a trial just for a claimant to say, well, yes, I've been working off book for a decade and I can't tell you what the money is because I spend it.
My lord, I accept that you shouldn't go to all the, if that was the only reason for the trial.
The claimant is required to plead and prove his case on impecuniosity.
But even if he fails on impecuniosity, he still has a claim for hire at the spot hire rate, and that is a claim that will go forward to trial no matter what.
And that goes forward to trial even if we're against you on this appeal.
Yes, but what the court would be saying then, they would be saying a man who doesn't keep accounts is not entitled to put forward the contention that he's impecuniosity to have it tested by a trial judge.
You can't simply assert it. That's why, because it was asserted in the particulars of claim. That's why there's an unless order in the first place, to try and tease out the detail.
Mr. Peter, this is the whole purpose of the rules which were brought in and the reforms that were brought in years ago. It used to be called trial by ambush, and that's what the rules and the practice direction are seeking to avoid. Get the detail out so that, as my lady has said, the other side knows the case they're facing, can assess the case in those circumstances, and if needs be, make offers of settlement. That's what the thinking is.
Absolutely, and that's what the reply does. The problem here is not that is that the claimant cannot put forward documents which he doesn't have to support his assertion of impecuniosity, but he can, however, say, I expended all my cash on daily bills, and in his witness statement.
So how much did he earn? He doesn't know.
It's not a matter of him not knowing. It's
well, he doesn't identify it in the reply.
If the court considers that that's something which ought to have been identified,
the district judge considered that it was something that should have been identified. He doesn't exist in a vacuum, and so on.
My lord, I'm sorry to press the point, but I don't say that's what the district judge was deciding, because the district judge was looking at the question of whether the claimant had complied with the order for disclosure, not what the content of the reply was.
Well, she says, I'm also asked to take into account by the defendants the fact that there are no details of income. The point that I've been putting to you, and she then expands that he can't exist in a vacuum, there must be evidence of his income, and so on.
What she was saying when she says there are no details of income is those are the words which are used in the order, which I can take, my lord, to.
I'm putting to you there's no details of income, so you've not complied with the unless order in any event, even if this had been served on the 4th of April.
My Lord, it's the difference between pleadings and evidence. I would strongly submit. If I say...
I agree with you, but the unless order said to plead, and that's to avoid, as my lady says, an ambush.
It pleads. The fact is, I say the fact is that the claimant expended the money he received from minicabbing on his daily bills.
And what was that? £100, £1,000, £10,000?
That's a matter of evidence.
Well, that's where we
point-
disagree.
Well, the point is that he's supposed to plead to show that the amount of money he made was not enough for him to be able to go out and hire a car. And that's why he has to use the credit hire organisation, and that's why it's going to end up being more expensive for the defendants because they charge more. But isn't it key then as to what his earnings are and what he's spending it? If he says all my daily bills, which include things which the judge then thinks, well, you could give that up and spend the money on hiring a car as you're a minicab driver, that's supposed to be what became clear from the service of the replies.
My lady, I do persist in the point that that's what should become clear from the witness statement, which sets out the evidence. I say that it's clear from the documents which are disclosed, because of course the bank statements will show the income going in. And if the claimant can only by way of his, not by his reply, which he won't rely on, but by way of his witness statement, I say that's important, by way of his witness statement, he will assert that he earned a certain amount of money, that it was all expended, and then he goes forward to trial, and the judge makes the determination based on a number of factors, but he's put forward evidence in the form of a witness statement of his earnings. He hasn't put forward evidence in the form of a reply. The service of witness statement was due, if I take my leg to the order, only 4 weeks after the service of these documents. If my memory serves me correctly, the order in question. I'm hoping it's in the. I'm hoping it's not another document, which isn't. I fear that it's actually not in the supplementary bundle. Of course, it wouldn't be.
I
There.
think the
52,
terms,
is it? 52 of the supplemental bundle is the order in relation to evidence of fact.
the unless
Yes, the unless order. Indeed. Yes. So, disclosure of documents. You see at page 52 that by the 2nd of May.
Yeah.
The signs and the reply, which is required, is of course by the 4th of April. So as I said, effectively 4 weeks. And it says that all facts in search suppose any assertion the claimant was impecunious at the commencement of. And I say it's the difference between a pleading and evidence.
So there is a statement.
Yes.
Right. Can we see that?
Well,
See what that says about income, because that would be relevant. Do you have that?
it can be provided.
Well, why don't you have these things?
Well, my lord.
The paragraphs 13 to 16 is a fundamental attack by the Deputy District Judge on the way in which the claimant has dealt with the question of impecuniosity. If you now say, well, it's a big difference between pleading and evidence, then it becomes rather important, doesn't it, for your case?
Well, Your Honour, I hesitate, but I will. I have to press upon you the submission that what the judge, I was there, and I was there at the appeal, so what the judge was dealing with there was not the issue of how the claimant had pleaded their case in the reply in any way. The judge was dealing with the insufficiency of evidence.
I understand that.
Yeah,
I understand that. But that is not the point I'm making to you.
Yes, I appreciate that.
Because I say, forget about the order about the papers. I say 13 to 16 is a perfectly reasonable series of statements about a claimant in this particular position.
Yes.
So whether in fact at the hearing that's what that was about, so be it. But I look at those paragraphs and I think, well, that seems on the face of it to be entirely fair enough.
Yes, but I suppose what I wasn't anticipating was being said was effectively that the reply needs to be repleted. I was anticipating that what the judge had said was well, it could be said an entirely reasonable series of statements about the insufficiency of disclosure, and the point that I would be making, and that I did make before the court below, is that if those documents don't exist, the claimant cannot produce them.
Well, that's an obvious point which goes nowhere. Of course, if documents don't exist, you can't produce them. But that's not what the district judge is talking about. She's talking about what's the income.
I'm sorry.
Anyway, there it is.
May I have a
The reply, I regard, speaking entirely for myself, I regard the reply as fundamentally deficient because it doesn't deal with the question of income and expenditure in a way that I think the unless order was designed to identify.
Well, if that's the case, then I say, of course, I hear the court's indication.
And that's just my view at the moment.
Yes.
So if there is something else that I'm missing, then by all means put me right. It's just that that's why I asked to see the reply, because I could see that what the district judge was saying seemed to go to the sufficiency or otherwise of the reply itself.
As I say, I would have to disagree with that. I say it's against the sufficiency of the evidence. If that were the case, and I accept what the court says, that it would be certainly it would be helpful to have those details, then I suppose the question is it becomes a question about proportionality. But the point is, I suppose, here is that it's the court. I say it would come into consideration if and when the court was to decide that the judge fell into error in her application of the Denton test, but then considered that this court was in a position, if you like, to remake the decision, rather than simply the claimant asked for receipt of sanction to be granted. If the court is going to reconsider the decision after having said that the judge's irrelevant considerations vitiated her decision, then that would be something the court would take into account. And I would say, well, the issue here is whether it would be proportionate here to, if you like, activate the sanction, or whether there might be a more proportionate way of dealing with this, bearing in mind what it's going to do to the claim. But I suppose the question is, does that analysis cure the defects in the way in which I say that there was a defect in the way in which the judge has applied Denton? I say it doesn't, because I suppose I see the difficulty, my lord. I really do. That if you say the reply didn't satisfy the order, then there's been no good reply even several months on.
Yeah.
But my lord, I do say that that's why I go back to the difference between pleadings and evidence, because if I set out, I accept that the bare assertion of impecuniosity is not enough to set out all facts. Equally, if from a pleading one can understand what the claimant is alleging, what the claimant relies on, then I say that's enough for it to be an effective pleading. So if I say, I was paid cash and I spent it all on my bills, then whereas that might be a brief pleading, it does set out that I did not have any spare money. And that is the essential point. I'm then able to amplify that in my witness statement. But the point is
The order doesn't permit amplification because you have to serve a reply setting out all facts in support of any assertion that the claimant was impecunious. So the witness statement would then simply effectively refer to the pleading and confirm the truth of it. It can't add facts because you have to set out all facts in the pleading.
My lord, I do think it would be dangerous for the court to go too far down this line, because all facts would be not only the income, not only the expenditure, but what each item of expenditure was, because of course that's a question about whether those are items of expenditure which ought to properly be counted.
It's a question of degree. I'm simply pointing out that you can't then have another go when you do the witness statement.
My lord, if it's a question of degree, then I say one does come back to the point of pleading and what pleading is designed to do, as opposed to what evidence.
No, it's the orders. Forget about what pleadings are designed to do. It's what you've been ordered to do in this particular pleading.
Pleadings require you to set out the facts. Yes.
All the facts.
All the facts. And you can't add facts in the witness statement. The fact is that he was paid cash. The fact is that he expended that cash on his daily bills. Those are the facts, and they're all the facts.
Anyway, the short point is you say that the sentence that I've read to you is sufficient to comply with the order.
Yes.
Okay.
Yes.
Yeah.
But even if it's insufficient to comply with the order, the question therefore, I suppose, is what should have been done as of the 21st of August, faced with an insufficient reply, and whether the district judge's decision there was outside the reasonable ambit of her discretion. My Lord, I hope you understand why I say that I ought to address that in the circumstances. And what I say is that even 5 months after the fact, or 5 months after the 4 months rather after the order, given that the claimant had disclosed all of his financial information, he had, and indeed, if one looks at the reply, equally information relating to his credit record, it is difficult to understand why and how any trial date was imperilled, or how the litigation could not proceed. As I say, all the orders had been complied with up to that point. The trial date was fixed. If the claimant was going to be in difficulty establishing impecuniosity, that is not a reason to debar him from making that contention. I say that's the important point here. It's the difference between a sanction and permitting the claimant to advance an argument, which I say he has pleaded, even in outline, and which he's able to support with reference to his financial statements. In that regard, he has disclosed a number of bank accounts, and none of them show any money going in or out.
No, because he says it's all done on a cash basis.
Well, exactly.
Bank accounts are not very helpful.
Well, exactly. So, but the point is, if he's a man who genuinely doesn't have any accounts, the court may take whatever view it wants of that. But I say
the court needs to know, and what the defendants need to know, is what he earns. Never mind what his outgoings are. The district judge knows what it costs to live. What needs to know is some basic things. What does he get per week? How many members are there that he's supporting with that money? Why is it he says, I don't have enough money to go out and hire a car. I wish I did. I had to go to this credit hire organisation. That's why it's going to be more expensive. That was the basis of what he was supposed to be showing.
I mean, I suppose the point is he's a minicab driver, my lady, and therefore let us assume, for example, that he earned £50,000 a year. He'd be doing very well as a minicab driver. There has to be an upper limit, and in these cases, my lady, even the spot hire rates for a vehicle which is a minicab vehicle are significant, and therefore assumptions can be made against the claimant. Assumptions could be made that he earned £100,000 a year. It may well be that he would still succeed in establishing that, be that as it may, it would be too much to ask him to make an unreasonable sacrifice and to pay the spot hire rate.
Yes, that's what everyone was trying to extract.
But if the assumptions can be made against the claimant, and if the claimant, I'm so sorry to press the point, but I say it's extremely significant. If the claimant does not have any documents to support whatever he says about his income,
well, that's a different point. He's got to say it.
He's got to say what his income is. Say what his income is.
Yes. And what his expenses are in a broad way.
My lady, I do say that if that is the point, then when one looks at it on the 21st of August 2018, and you say the claimant has not provided the detail of his income, not provided the evidence, but not provided the detail of his income, then the question is, could that information be provided without disrupting the orderly course of the litigation? And the answer is yes, of course it could.
Well, why wasn't it? In the order the unless order that was made.
Because, as I say, as I say, my lords, I do say it's with the benefit of experience with these cases, the income in terms of the number is not pleaded, because it can often be a bit of a false friend. It can be higher, it can be low. What is required is to put forward the documents which support that, and if they do not exist,
No, with great respect, that's no wonder these cases are such a problem area, if that is the approach. It's not a question of documents. Leave documents aside. I can't afford to hire a car and pay for it myself because my income is only X.
perhaps I can explain it like this when you look at the timetable, my lord, and perhaps that's the way to look at it. What is not obtained at the time of service of the reply, and what is not ordered to be exchanged at the time of service of the reply is what is known as rates evidence, that is spot hire rates evidence. And indeed, as I say, so the point is that those the issue of how much the claimant could have afforded is not something which is actually crystallised at the point of service of the reply. What the claimant says usually is that he simply couldn't have afforded any sum. So it's very difficult to ask the claimant to put forward the details of not only his income but then all the details following about how much he would have been required to pay, because that's often evidence which is not in existence at the point of service of the reply. So I'm trying to give an explanation of why it is that perhaps a reply to defence in this case doesn't look like what the court is suggesting it should look like. What the reply to defence does is it sticks the claimant to his pleading of impecuniosity, and it forces him to say in a verified document that his income is not sufficient. It forces him to
He doesn't
explain
do that in the reply.
Well, he says he's paid cash. He does. He says paid cash and it's expended on his daily expenses. That does say that. I'm sorry to say. But he also deals in...
Anyway, I think we've been round those houses.
Well, yes, I accept
There's
that.
no plea of what his income is, whether that's what there should be or shouldn't be, there isn't.
There's no plea of his income, but to penalise the claimant for that in circumstances when I press strongly on the court that it would be counter to usual practice for there to be that sort of pleading, I say would be very difficult. The judge really was not saying the reply is inadequate. It was, I'd say it was. There was no demur from the submission which was made that this was a full and detailed reply that was served only 5 days late, and as I say, so that and back round the houses, it was a disclosure point, and it wasn't a pleading point. So that's why I pressed the submission on the court. So looking at that, there's analysis of perhaps you could say there's analysis of what you could also argue, my lord, are weaknesses in the claimant's case. He's going to have trouble proving that he's impecunious. But I do say that it would not be appropriate to place too much reliance on that. Even at the third stage, taking a full third stage consideration, one shouldn't consider unless the merits are so obvious as to mean that effectively that the point could never be won. One shouldn't take into account the merits of the case. The question should be focused on the very breach. And in that respect, that's why I'm pressing the point about the reply, because, as I say, in the context of credit hire litigation, it was a full and detailed reply which annexed all the relevant documents that the claimant had. And there you have the point.
Yeah.
Really, in terms of the district judge's judgment, it's where you end, because that's the last point the district judge made, and apart from what she calls an overriding concern that this was a road traffic accident from 2014, says that if impecunious is going to be part of this case, then the information relating was going to be needed at the beginning. They had plenty of time.
Yeah.
Goes back again, I say, to the explanation.
The explanation.
The explanation, there's no good explanation for the failure to comply. It doesn't.
No, it's more fundamental than that. She's saying that the question of impecuniosity was always going to be front and centre,
Yes.
and the claimant ought to have addressed it from the outset.
Yes, but the claimant did have the relevant documents to effectively 2 days late to serve them. They were all served with the reply. So I say that shouldn't be a very weighty consideration, even if it ought to have been clear from the outset. It really is. I say sort of nibbling around the edges, and it should not be described as an overriding concern.
Okay.
As I say, I mean, this is as Coulson says, of course, this is an appeal against the decision of the Deputy District Judge, and especially given that His Honour Judge Lethem, I say, effectively adopted the District Judge's reasoning. I don't propose to take the court to his reasoning.
No. Well, I think as Lord Justice Lewison's made clear in another case, in these sorts of circumstances, on one view, what the circuit judge said or did is immaterial. I mean, obviously, the effect of it was that it's led to a second appeal, but it's what the district judge did that matters.
I said the type of brief. I've perhaps been slightly less brief than I anticipated.
Well, we've had points to put to you because there are points that seem to us to arise out of these papers. So you're going to arrange to send me and us immediately after we rise the application notice, because you say that contains the statement from the solicitor, and you're also going to send, if there are attachments, we don't need them, but we'd like to see the statement that was served on the 2nd of May.
Yes, no, that's something that both of those documents can be provided immediately after the hearing. If I may just briefly draw the threads together, because as I say there's a slight risk of getting sidetracked and not I suppose highlighting the fundamental point here, which is that this was a reply served only 5 days late, and that had the defendant consented to the application for relief from sanction, the other issues which have been raised at the end previously in my submissions could have been dealt with in a far more proportionate and expeditious way. In that the defendant was saying, well, we don't have any documents which evidence your income, and the defendant then, of course, could have consented to the application for relief from sanction in respect of the reply, service of the reply, and could have made an application for specific disclosure of the documents that it said, and that, to be fair, the district judge said, ought to be in existence. That, I say, would have been proportional litigation and would have avoided the type of satellite litigation which doesn't go straight to the point that we had in this case. I'm sure my learned friend will say what the defendant was complaining about was the absence of the documentation. They were not complaining ever about the inadequacy of the reply. And therefore, I fall back on my point that the appropriate way, and it's indeed the only relevant way to deal with this application, was to say that this was not a significant breach, and that therefore that any further considerations must outweigh what is, I say, in almost all circumstances, something which points to the grant of relief. And if that could be dealt with, any of the further considerations, if they ought to have been dealt with, or if they could be dealt with by a means more proportionate than a debarring order, then in my submission, that was what ought to have happened.
Yeah.
Those, unless I can insist, those are my submissions.
All right, thank you very much, Mr. Peter. We'll rise.
All rise.
We just need to be outside for a quick conversation.
Gentlemen, I'm not sure how long the judges are risen for.
Oh, I assume they'd be rising for a sort of period of around 5 minutes.
They didn't say how long.
Oh,
for.
no, okay, fine, okay.
So I don't want to be in a position where they.
No, it's only because I'm mindful this is being live streamed, otherwise I'd sort of have a, but I suppose I can speak in understanding to my instructors.
That corner over there
Okay.
is not like covered by us. Hi, I'm Nicola from Coulson. The judges have just risen. They didn't say that how long. I presume it might just be there. Do you want me to stop the streaming or not? Well, the thing is, I don't know. And I know that you've got problems with it by switching off the query reset and all that. I don't think it's wise to turn it to stop it, but I just wanted to check with you, that's all. Yeah? Okay, I presume that's what they've done, but they didn't say. Okay, so I won't do anything, I'll just turn it off when the call ends. Okay, cheers. Court rise.
Mr. Fardy, it would, I think, help us to ask you to deal first with the question of sign for first class post, and then in relation to the relief from sanctions element of this, we have your replacement skeleton, which we've read. So we would probably simply ask you to help us with anything you wanted to add to that. Take that as read. Anything you wanted to add, particularly if there's anything coming out of the exchanges that we've had with Mr. Peter that you want to comment on one way or the other. Is that all right? So
Yes,
I think really those are the two areas that would assist us. You can take your second skeleton's read, so you don't need to go through the points made there.
Thank you, my lord. In which case, yes, I will turn to the service point. This is, of course, a matter that Lord Justice Holroyd identified as a matter which is of some general principle. And indeed, picking up on what my learned friend said in his submissions, whether or not the document itself was deemed served 2 days or 5 days after the due date doesn't actually bear significance. Those were the claimant's words. And so what we are really dealing with now is a wider principle point, as Lord Justice Holroyd rightly identified. The principle is the question of how signed for posts should be dealt with, and whether in particular it is analogous to and adopts the rules that apply to first class post. And my lord, my ladies, you will have my skeleton argument, paragraph 13, which I think is on page 30 of the core bundle. The revised version is 222 of the authorities bundle, which breaks down, as it were, the way in which I will address this service point, the three questions. First being whether or not the signed for delivery service used falls within the meaning of 6.21b, first class post, document exchange or other service which provides for delivery on the next business day.
Sorry, Mr. Fardy, I was just looking for something else. Paragraph
Paragraph 13.
13.
Yes, 1-3.
Yep,
It's
yep.
page 30 of the core bundle. First question is whether it falls within the first class post rules. Second, if it does not, then does it fall elsewhere? And thirdly, what's the impact, of course, on this particular matter? As to the first question, I propose to address that in 4 ways. 1, by looking at what the rule in fact says. 2, looking at how the rule came to be developed. 3, looking at the purpose of service more generally. And 4, looking at the effect of deemed service, if indeed signpost does apply to first class post rules.
Mm-hmm.
Looking then firstly at the rule, we have, of course, this reference to a service which provides for delivery on the next business day.
Mm-hmm.
Now, in the context of first class post, of course, it is hoped and assumed that that will take place. In signed for post, we have, I say, the introduction of a new condition. And it's a condition which is best articulated in the supplementary bundle at page 38, which is the terms of this particular service that are used.
Yeah.
Page 38 of the supplementary bundle brings up 20.1 of the terms and conditions.
Yeah, the explanation of what signed for first class is.
Yes.
Yeah.
And the third line under 20.1, second and third line, Royal Mail signed for first class and second class items will only be delivered to an addressee or their representative once a signature or similar proof of delivery has been gained.
Yeah.
So here we have that introduction, and that, I say, is the starting point for which signed for services depart from first class post in the actual language used, because delivery is, as it were, different. The second is the context in which the rule is made, and I shan't repeat what's in my skeleton argument. I'm grateful to my lord and my ladies for identifying it. You've had opportunity to consider it. It's paragraphs 18 and 19 for your notes, which is on 32 of the core bundle. The way in which this rule has come to be formulated, in the way in which we now see it, is through an update in 2006. And that update was due to the Royal Mail's monopoly on the postal service ending. And the explanatory notes to the civil procedure rules provide that the rule was amended to allow parties, quote, to use equivalent services as well as first class post for service of documents. And so if one is then addressing whether or not this signed for service is an equivalent service, I say it isn't, because it introduces that further condition.
You can't construe the rules by reference to the explanatory notes.
It's not, I agree. It's not
I mean,
a direct matter of interpretation. It's
CPRC, we
contextual.
have enough trouble doing the rules. We are not responsible for the explanatory notes, and they, I'm afraid, are often wrong.
My lord.
Or they often, that's not fair, they often simplify to explain something in a way that, you know, is not to be taken as gospel.
My lord, yes. And indeed, there are perhaps some caveats to the submission I make as you've identified. But I do say it at least provides an element of context.
But insofar as the other service providers, not the Royal Mail, also offer either just an ordinary first class, well, they don't, because they don't have post boxes, do they? But I assume some of them will offer both just a delivery service, we just push this through the letterbox, or a signed for service. So the Royal Mail can't be in a worse position than the other service providers.
Indeed, my lady, and my lady is right in saying that other service providers, Hermes, Whistle and the like, will likely have tiered services wherein there is a service that is simple delivery, and it is hoped that that will be delivered the next business day, and there will be more secure methods. What I say is those alternate services that are provided at the lower end of, if you like, of the standard of service, those that don't require a signature, are analogous to first class post because they do have effectively the same terms, that the intention is that post will arrive on the next business day without any further qualifying criteria. Where those other providers have signed for services that require a delivery, a signature at the point of delivery, then I say that those would also fall within my interpretation and fall elsewhere. So if I perhaps move on then from context and look at the third point, which is the purpose of the service rules more generally, and I hope it's not contentious that, of course, the purpose of service is to ensure that documents are brought to the attention of the intended recipient. Now, in the context of first-class post, there are, of course, some deeming provisions, and perhaps the rationale for those is that the sender is unable to say with any certainty if documents have in fact been received, and if they have, when they were received. And so when one looks at the purpose of the deeming provisions as they relate to the rule we're examining, as it relates to first-class post, if I can turn the court to the authorities bundle at page 141, and this is the Godwin case.
Sorry, this is the authorities.
Yes, authorities bundle, page 141.
I'm afraid mine aren't numbered.
Well, it's tab, I think it's...
And are not tabbed either.
It's
But
about this far through.
but how many? Where is it? Godwin.
Godwin, yes.
So the one before Kennedy. Yeah.
Yes.
Yeah. Got that.
Godwin, by way of very brief factual summary, because the facts are to an extent important, the claimant in that case had to serve a claim form by the 8th of September. On the 7th of September, they posted the claim form by way of first-class post. It did in fact arrive on the 8th of September, but the defendant took the point that because the deemed service rules mean that it isn't deemed served until the 11th, because the 9th and 10th were a weekend, the claim form was received out of time. What the appellant sought to do in Godwin was argue that actual service could displace deemed service so that the claimant got the benefit, as it were, of knowing that the defendant had received the document in time. At paragraph 60...
And what was the answer?
The answer was that actual service cannot displace deemed service.
Because in accordance with the rules, it was served out of time.
Yes.
Yeah.
And paragraph 60, 60, which is the judgment of Mr. Justice Reimer, paragraph 60 begins with the purposes of the deemed provisions in the context of first-class post. at paragraph 60, he says that there are two purposes. One is to fix a convenient date from which time runs, the setting, of course, of timetabling under the rules. And the second, at paragraph 61, is that the sender is going to be unable to know and prove, in the event that somebody doesn't respond, that a document has actually arrived at the intended destination. Those, therefore, are the purposes behind the deemed service rule as it relates to first-class post. And there is one final purpose behind them, but that purpose is found in the Anderton case that precedes Godwin in the bundle, postdates it in time. The relevant passage that I refer the court to in Anderton is paragraph 36. 36. That is on page 124. I'm reading from the judgment of Lord Justice Mummery. At the top of page 125, we have, on around the 5th line down, the question there of the objective. It reads, the objective is to minimise the unnecessary uncertainties, expense and delays in satellite litigation involving factual disputes and statutory discretions on pure procedural points. That therefore provides the underpinning rationale as to why first-class post is deemed served 2 days later, because the moment it goes into the post, the sender can do no more about it, and the sender therefore has to rely upon the deemed service rule. I say that signed for post is removed from those concerns, and that in fact it actually rectifies a number of the perhaps problems that are inherent with first-class post, and therefore the purposes are not shared. Because in the case of signed for post, we have a precise date upon which a document is received.
But they had that in Godwin and it didn't help them.
They did. That was because of the operation of the rules. And my lady, you're right. What I am inviting is that because the signed for services have ways in which that problem can be circumvented, it takes it outside of the rule that applies to first class post, but does put it in somewhere else. And perhaps jumping slightly ahead to what will the ultimate point of my submission will be, I will invite the court to conclude that signed for services attract the service provision that's relevant to leaving or delivering a document to a particular place. Under the deemed service rules, that is the date upon which it is delivered or left at that particular place.
But isn't that supposed to deal with, if you don't use any postal service, you just take it yourself? I mean, everything is ultimately left or delivered, whether it's by the Royal Mail or by Whistle or Hermes or whoever. Isn't that other one to do with, if I take it myself and put it through the letterbox, then I'm leaving it or delivering it?
I say that would be captured by it, but it's not as exclusive as that.
Well, then when is there which kind of delivery is not within the leaving and delivering then?
First class post.
Well, why? I mean, somebody takes it from the post box, trundles it around the sorting office, and then the post person goes and delivers it or leaves it at the address.
That does come back, I say, to the rule itself. The rule provides for first class post to have this deeming provision. And again, perhaps the effect is more historical. It goes back to a time where first class post perhaps was, albeit it still remains to an extent unreliable, certainly known for some unreliabilities. And 2 days was set as the date by which there would be certainty in the progression of the claim. I say that with signed for post, we don't need to have that. We don't need to do that.
But you say that almost as if certainty is a bad thing, that we don't need it. I mean, it's a good thing, surely. You have certainty. You put it in the post, whether the case obviously depends on whether there's a difference between signed for first class post or first class post. But the sender puts it in the post and that's that. They don't need to worry about it because they are then subject to deemed service. Whereas, if you're right, even though you're using first class post and you've got what an ordinary person might think of as the add-on of signed for, the sender is not going to know and is not going to have that certainty, and they'll be ringing up to make sure that it's actually been delivered.
I say in terms of the position of the sender using what might be deemed to be the better service, the difficulties for them work both ways. And perhaps the best way that I can answer my Lord's question is by putting a litigant in person who uses one of the better services, one of the guaranteed next day delivery services, in the position of the claimant in Godwin. The court will recall, of course, that on that occasion the document was sent by first class post on the 7th, and as a consequence it was out of time. If it is right that the signed for services attract the same deeming provision, then a litigant in person who on the 7th uses the Royal Mail's guaranteed by 1 p.m. delivery, and we know that's a service that's available, it's in the supplementary bundle, they use that service. That service works as expected. A proof of delivery is generated wherein everybody knows, the claimant and defendant both know when a document was received. The consequence, despite the fact that the post has worked in the way in which it was intended, is undermined. Because the sender in that occasion, despite having quite understandably used a better service, is being penalised.
So that's what happened in Godwin, as my lady pointed out.
Yes, that of course didn't have the same specific benefits of a special service. That was first class post, and the court quite rightly, I say, noted in that case that it was no more of benefit to the claimant that the document had been received on time than it would have been to the defendant if received late. The point, of course, with a signed for service is that you have generated a proof of delivery which sets beyond all ambiguity the date on which a document was received. And we know that in the present case, for example, not only was it received on the 9th, it was received at 11:13 a.m. That, I think, then jumps me through, in some ways, to the fourth point that I mentioned, which was the application of deemed service rules as they relate to first-class post to signed for post. I've already mentioned the one problem that I see arising, which is that litigants in person who use a better service are effectively impacted detrimentally. The other matters, of course, are that there may be claimants who are in better positions. And I've set out some examples in my skeleton argument. I shan't dwell on those. It's paragraph 33 and 34 for your note, if it assists. But perhaps the principal issue is that a sender of a document who is able to know if and when it has been received, and of course therefore is able to know that it hasn't been received, could still take the benefit of the deemed service provisions and say, well, I'm entitled to default judgment 14 days later. And so therein lies, as it were, prejudice to all sides.
Sorry, say that again. The sender who's able to know that it's not been signed for.
If the signed for postal service has the same deemed service rules as first class post, then a sender who knows, because they haven't received a proof of delivery and they haven't received that confirmation, knows that the document hasn't actually been received by the intended recipient, can still wait 14 days, rely on the deemed service rule and say, well, it was deemed served, even though I know as a fact it hasn't been received, and obtain default judgment.
Yeah.
They're able to do that.
Yeah.
Now, what I say that does is it introduces an injustice.
Well, why?
Because the
defendant might deliberately not being taken delivery of it, pretending to be out.
yes,
I mean, all that used to happen a huge amount. And so we changed the rules to try and make it more certain and try and do away with that sort of stuff.
yes. Well, I say that with signed for post, the doing away with uncertainties, as it were, is done by the service it doesn't need to be done by the rules because the service provides the date on which a document is received. And I go back, of course, to the core concept of service. It's to know that a document that has been sent has in fact been brought to a party's attention. That, I say, is the benefit of the proof of delivery. It provides a far greater degree of certainty than a deemed service provision for first-class post.
It is It is interesting when one looks at 626 on deemed service. There's no reference there at all to any concept of signature. It is all deemed delivery, and that replicates the wording of these, what are they called, the Royal Mail United Kingdom Post Scheme, in particular 9.3 and 9.4. 9.3 deals with what I might call ordinary first-class post, and 9.4, the signpost. It's all the same wording. It is the delivery, and there is next working day within the rules, or next business day within the CPR. Nothing about any signing.
Yes, and
so again, a consistency, and what some may say is a certainty.
I think I am bound to say that the signed for service does, in a sense, provide for delivery on the next business day, in the sense that it has the opportunity, or it's within the intention of the service, that it will so happen.
Well, if I may say so, if one only looks, it's page 21, the supplementary bundle, 9.3, which deals with ordinary first class, 9.4 sign, you're seeing the same words. We aim to deliver a first class item the next working day after it's been posted. 9.4, this is signed, we aim to deliver a Royal Mail signed for first class item next working day after it's been posted. The same wording.
Yes, and insofar as the intention on how quickly the Royal Mail will provide that service is concerned, they are indeed the same. Mm. The issue, of course, in the case of signed for post is that when the Royal Mail say, we will intend to provide this on the next business day, the very nature of the system means they have to include, almost as a caveat, we will intend to deliver this on the next business day, provided somebody is there to sign for the document. And I say that it goes beyond, as it were, semantics. It goes to the core concept of service, and it goes to the core concept of the rule itself as to why signed for post is materially different.
All right. Now, you've taken us to Godwin and Anderson, understand that. You also referred to Kennedy. Is this right? The reference to Kennedy is simply because it's making the point that a deemed provision is a fiction, I think at one point it's referred to, which of course it is. Is there anything more in Kennedy than that? Does it help us on this issue?
Only briefly, insofar as Kennedy at paragraph 134, which is on my page 207 of the bundle. Kennedy cites with approval an earlier case, Inland Revenue Cons and Metro, and Mr. Justice Norse's comments. And the only other
what are we getting from that?
The only other matter of relevance is towards the end of that section. It says, if the application of the provision would lead to an unjust, anomalous or absurd result, then unless its application is clearly within the purpose of the fiction, it should not be applied. This, I say, is the problem with adopting the first class rules for signed post. The deemed service provisions would apply if they produced anomalous, absurd or problematic results. Then that would still, if the law is interpreted in that way, be within the purposes of the fiction, as is commented. And so the litigant in person who sends a document by next day guaranteed 1 p.m. delivery is stuck where they are. And there isn't, as it were, a discretion on the part of the court to be able to say, well, we recognise that the document was brought to the attention of the recipient, that it was brought so because of the service you used, but you're still stuck with deemed service provision because we can't disapply it. It's within the purpose of the fiction.
Which was presumably why Godwin was decided as it was.
Yes, Godwin was
Because
decided.
that's within the purposes of the fiction.
Yes, and the purpose, of course, of the fiction was that first-class post is inherently uncertain on the part of a sender in knowing when a document is received, if it is received. And so it has a purpose, as it were.
Well, the purpose is the certainty.
It's the certainty that comes from the uncertain first-class post service.
Well, there's uncertain first-class post, there's somebody might be away, there's all of that stuff, and the court doesn't have to get into any of that because it's just deemed served 2 days after it was posted.
Yes, and if in future claimants continue to use first-class post, as in the vast majority of cases I would suggest, then there would be no change, and the deemed service provisions continue to apply.
Yeah, no, I understand that. We're concerned with the signed for version of it.
Yes.
And yeah, okay. Well, I speak for myself. I'm not sure I gain a huge amount from that passage, but okay, that's the point you wanted to make by reference to Kennedy. So,
Yes.
is there anything else you want to say on that first point, the deemed service point?
There's a couple of final matters insofar as Petford is concerned. I don't propose to go into it. You have, I think, the case of Petford referred to in my skeleton argument. Regrettably, of course, it's low-level reporting. It being a county court decision means we only have an abstract.
Yes.
So it appears on page 209. Of course, it's an inherent problem that we aren't able to see the fuller version, but you have my submissions in the skeleton as to why I agree with that only in part.
Yeah.
I think touching briefly on a point that my lady raised insofar as methods of service that would fall within what I say do apply, and that's the delivering to or leaving at section of 6.20. Can I invite the court to very briefly consider one of my learned friend's cases? And that is the matter of Viridor Waste Management in Veolia. And I do so at paragraph 14, which is on my page 49 of the authorities bundle. In
Viridor paragraph
14,
Yeah.
the court there is examining the contention on the part of the claimant, and I do emphasise that this isn't the court's approval of this section, but it at least gives some context into the submission I was making earlier, that, as it were, a number of services can fall within the relevant service provision that I've identified. It says there in the question of second-class post, fourth lines down, so satisfying, CPR 6.21c. That is the service provision that deals with sending or delivering to a particular address. And so if second-class post can fall within the meaning of 6.21c, as I invite the court to so find, then so can other means of postal services. And the benefits, of course, I think I've already touched upon in addressing the problems, as it were, with first-class post. One is a corollary.
Well, I've already picked you up on that. I'm afraid I don't see there are problems, as you have repeatedly submitted, and I'd be very concerned about shoveling more things into the delivery category, because that's where the uncertainty, that's where you get the uncertainty. It was never delivered.
I say that with regards to the signed for services, and in particular the one that was used in this case, there isn't such an uncertainty because we know from the proof of delivery that it was, in fact, so delivered.
Well, on the facts of this particular case, yes, I get that. Okay.
And very finally, I think if there are any negatives from the interpretations that I've invited, then one has to see that in the context of somebody choosing, making a free choice to use a signed for service. And therefore that sender should be taken to attract both the benefits of the service if they work in its favour. And I go back, of course, to my litigant in person example in Godwin who's using a guaranteed form of delivery. But they should also, of course, be encumbered with the negative and the detrimental impacts.
Mm.
And that comes in large part from the fact that these matters are being done at the last minute. So the simple headline point is, if a claimant wishes to use first-class post in the standard sense, it can do so, and the deemed service rule will apply in the ordinary way. If it intends to use a signed for delivery service, then of course that has benefits in the service itself. It may also have detriments, but it's a free choice.
The trouble is, if you're going to use the signed for, how far in advance of the deadline for the document being served do you have to send it?
In the ordinary course of events, it should be a working day. And so if we have, for example, the special delivery guaranteed by 1 p.m. delivery, then in the ordinary course of events, that should be able to be sent on the Thursday if it's due on the Friday. I recognise my lady's point. I think that that may not in fact happen.
So I could be a person, which I am, who doesn't leave things to the last minute and send it a week before. But if I send it to be signed for, even that doesn't give me certainty that it will be served in time.
Correct. That comes, though, from your choice of use of the service rather than the operation of the rules. And so, my lord, my lady, that's the way in which I invite the court to interpret those rules.
Yeah.
The effect on this case, I think I've already addressed you on in saying it's inconsequential either way, because the service point, whether it's 2 days or 5 days, makes no difference. And of course, as a matter of fact, insofar as the learned district judge and the learned circuit judge made comments about the fact that having a requirement for somebody to sign for a document can cause problems, that as a factual assertion is entirely right. What of course would be challenged is that it's not deemed service after 2 days.
Okay, so then we come, I think, to relief from sanctions.
Yes, and I'm grateful to my lord for your earlier indication, because I can address this very briefly. In short summary, all of the matters upon which you have been addressed are properly construed matters of an exercise of discretion. And of course, the hurdle the appellant must overcome in such cases is far, far higher than simply identifying an error of law. And in summary, another judge may well have come to a different decision. Another judge may have considered that this matter was less serious or less significant than the learned district judge did. But that is not a reason to grant the appeal. In briefly on some of my learned friend's submissions today, he says that the defendant, for example, should have consented, and the problems, the impact on the litigation that has arisen arises because the defendant did not consent. I say that consent is a matter that goes to cost. It's a matter that was quite properly addressed in Denton, and again quite properly. The court said if there is opportunistic resistance to an application for relief, then that party should be penalised. But what that doesn't do is circumvent the requirement on the part of the party who requires relief to make an application and seek that permission. We know from Practice Direction 23 that an application has to be made as soon as it's reasonably required, And we know from the effect of the debarring order that it takes effect the moment there's non-compliance. And on any version, there is non-compliance here. So the claimant was always going to have to make an application. When did they in fact make the application? Well, it was issued on the 5th of June, and the breach took place on or around the 4th of April. So there's 2 months there. My learned friend has, I think, quite properly today conceded that the finding of the learned district judge was quite proper, that this was a late application. Insofar as the claimant says, well, it was in part delayed because there was a back and forth between the claimant and defendant about whether or not an application should be required. Well, I say, one, it was always required in any event, but two, on the facts of this case, we know from the learned judge's decision, and if I may just turn it up, I believe in fact the chronology in this sense comes from His Honour Judge Lethem's decision. We know that the defendant did in fact oppose or indicate that it would oppose an application on or around the 17th of April.
Yeah.
And so that takes this matter apart from, for example,
so it's by the 17th of April it had become apparent on any view to the appellant that they needed to make the application.
Correct.
Because the defendant said it would oppose it.
Correct.
So the lines were drawn then, you say?
Yes.
Yeah. So you say at the very least it's 6 or 7 weeks went by without any explanation.
Yes. And insofar as the appellant complains that the defendant ought to have consented,
Yeah.
that is a matter that's relevant to cost. It's not relevant to whether or not the application should be made. Turning, I think, back to the decision of the Deputy District Judge, my learned friend has, in large part, sought to focus his attack on stage 1 of Denton. And that the learned judge didn't consider significance.
Yeah.
As I interpret the submission, it is in fact an exercise, and I say that this is an interpretation that was supported by His Honour Judge Lethem. The attack is actually on stage 3, because what the claimant says is she ought to have placed the matter lower on the scale, not that she shouldn't have gone on to stages 2 or 3. And what Deputy District Judge Goodman, of course, said is that at the top of top of page 94, paragraph 11, it's been conceded that it's a serious breach. You've been taken to Denton, and what Denton, of course, says is if a breach is not serious or significant, then we need not consider stages 2 or 3. Well, here the judge has concluded it was serious because it was on concession on the part of the claimant. So she was bound to go on to stages 2 and 3. There is no error there. Insofar as there is a challenge, as it were, to the reason, that's paragraph 3, or in fact I think my learned friend concedes that that was a finding the learned judge was entitled to make. Paragraph 6 at the bottom of 92, that the claimant misunderstood the rules of timing. This is, of course, the separate point from the service point. This is that the claimant thought that when they posted a document, it would attract the service provisions relevant to claim forms, whereas this, of course, was not the case. The service provision was under 6.20 and not Rule 7.5. And again, that's not been challenged as a finding. And then as the matters 13 through to paragraphs 13 through to 16, I don't feel that I need to address you further unless it would be of assistance, because it goes back, I say, to my overarching submission, which is that these are matters within the judge's discretion.
In relation to significance, Mr. Peter's principal point appeared to be, well, it didn't have any effect on the timetable. What do you say about that?
Well, His Honour Judge Lethem has perhaps more appropriately addressed the matter than I may be able to today. What he effectively says is that's not the focus anymore of Denton. Denton is considering the application of Rule 3.9, and 3.9 is looking at litigation to be conducted efficiently, proportionately, and enforcing compliance. And as it were, the focus on the part of the appellant on trial date was a bit of a misnomer. His Honour Judge Lethem notes, for example, that if the appellant was in time, or indeed if he was out of time but applied promptly to obtain relief, then the defendant could have at the front and centre of its mind that impecuniosity may well be something that needs to be challenged. And that can be challenged, of course, in two principal ways. One, it can be challenged at trial. And until the claimant makes their application, application for relief, the defendant, I say, is entitled to consider that because the unless order has already bitten, the matter's put to bed. But the second point, of course, is this question of sufficiency of disclosure. And what my learned friend has said is, well, if it was properly granted and it was considered that there were some concerns about the extent to which the claimant had provided documentation, then the defendant can make an application for specific disclosure. Well, on the claimant's timetabling, the defendant has only got the opportunity from August, when this relief application is determined, to the trial on the 1st of November, in which to formulate that application, make it, have it heard, and then consider the consequence of that application. Because if, as a consequence, the defendant takes a proportionate and perhaps more pragmatic view that impecuniosity is likely to be founded, and therefore there isn't point in wasting funds on getting a basic hire rates report, that opportunity has been deprived. The defendant has got to, as it were, set all the hairs running at the outset, just in case the claimant goes to fix matters later on. And so I say that there is, as it were, significance in any event, but that the way in which the learned judge dealt with stage 1 of Denton was not incorrect. It was dealt with, as I think, my lord, you identified, in the course of a 30-minute telephone hearing, with some other difficulties and with a number of matters that she had to address. And I say that she has done so within the remit and ambit of her discretion.
Yeah.
Unless there's anything further, my lord, my ladies, those are my submissions.
No, thank you very much, Mr. Farley. Yes, Mr. Peter, is there anything you want to say in reply?
Yes, not on the first point, but on the on what my learned friend says about relief from sanction and his characterisation of Denton. In particular, well, there are 2 points. The first is just one clarification. My learned friend suggested that there may have been disruption to the course of litigation because the defendant might not want to get basic higher rates evidence if the point of impecuniosity was not an issue. But as I understand in this case and in all cases, one always gets basic higher rates evidence. So that's an expense which is incurred. It has to be, because otherwise the defendant can't prove what the basic higher rate is. And so I say it's a non-point. It's a minor point, but I wouldn't want the court to be under the impression that there was some evidence that the defendant could have got, but they didn't because of any delay in the application of relief from sanction, or indeed the operation of the sanction. That's simply not the case.
And just in terms of terminology, am I right? Basic hire rate, that's the same as spot rates?
Yes.
And somebody criticised the use of the expression spot rates, but I noticed Judge Lethem uses that expression all the way through, but he's been a judge for a very long time, so perhaps that's just habit. But anyway, they're the same.
They're analogous.
Yeah, fine. Yeah, okay.
So there's that point. But then the what my learned friend said was in terms of the question of the claimant's delay and what the effect of that was that, well, the defendant made it clear by 13 days after the default that it was going to oppose relief from sanctions, so therefore an application had to be made. And in fact, Denton does have something to say about that, and it's at paragraph 41, page 77 in the bundle. This may also require a reference to CPR 3.8 subsection 4. It may be that the court doesn't need me to refer specifically to the rule, because I can characterise it. That is when parties may only agree an extension of 28 days by agreement in writing if an order contains a provision which effectively is a sanction. That's 3.83 and 3.84. I'm very happy to give the exact wording to the court, but essentially I hope the court can see what I'm saying, which is that what Denton enjoins parties to do is not force an application incurring unnecessary costs, but rather to, when a limited extension can be agreed, which it could have been in this case, notwithstanding that the date for compliance had already passed, then that would be the appropriate way for the defendant to deal with it. So I say that the defendant, the respondent, can't rely on what I say is its unreasonable refusal to agree such an extension, to say, well, look what the claimant did. The point is that the claimant, I say, ought never to have been in a position where it had, as my learned friend says, had to make an application for relief. It's not what Denton considers. I can't see a statement in Denton anywhere which says that an application has to be made in circumstances where parties could agree, pursuant to CPR 3.8 subsection 4, a limited and reasonable agreement of time, which they could have done on the 17th of April, the reply having been served by then.
Right.
Mark's reference to say, forgive me, my lord, I won't be very long. Yes, it's only the final point is to highlight, so as my learned friend has said to you, well, the judge was entirely correct at the first stage. My final submission is that I point to paragraph 27 of Denton, and I've mentioned this phrase before, but I would like to end on it, which is it's the seriousness and significance of the very breach, and I say that's absolutely key in this case. In terms of the other submissions by my learned friend on relief from sanction, I say.
So, 27, what point?
27, it says at the first stage, it's the second sentence at the third line down. The court should concentrate on an assessment of the seriousness and significance of the very breach in respect of which relief from sanctions is sought.
Yeah.
And so that's that. And I suppose what it goes on to say is that if a judge concludes that the first paragraph 28, the breach is not serious or significant, the question here is, I suppose, if a breach is a certain degree of seriousness but is not significant, I say that the consideration in stages 2 and 3 is truncated to reflect the lack of significance. And I know I've made that point before, but I just wanted to be clear that that's why I say that the detailed consideration that the judge, Deputy District Judge Goodman gave to the third stage is not apposite in circumstances when she ought to have concluded that it's not significant. Not that she shouldn't have gone there at all, but it's the weight in which those factors are ascribed, and that is not a question of remaking the judge's discretion. It's looking at the principles on which that discretion is exercised, based on what I say was a misapplication of the first stage, not an exercise of discretion.
Yeah.
My lord, my ladies, if there's any other points which you would like
I'd like those documents.
Yes.
So when can they be sent? Are they?
May I turn my back for a moment?
Yeah.
My instruction solicitor says that he'd like to send them when he gets back into the office, which would be about an hour, and he can say he can do it within about an hour.
Right, because we'll be working on this afternoon, so that certainly will need to be. If that can be done, that would be great.
Well, may I say before, by hook or by crook, before 2.
Fine. Okay, and I think my clerk certainly has been in touch with the parties, so he has her email address, and my clerk can then pass it on to my lady's clerks. All right, thank you both very much. We'll obviously reserve our judgments. You'll get a draft in the usual way at some point, I hope in the not too distant future. The draft is so that you can check our typographical and related errors. It's not to comment on our reasoning. Thank you both very much.
All right.